Committee will come to order. Without objection, the chair is authorized to declare a recess of the committee at any time. This hearing is entitled Legislative Proposals for a More Efficient Federal Financial Regulatory Regime. Before we begin today, I'd like to thank the witnesses for appearing. We appreciate your participation and look forward to a productive discussion. A number of you have been here before, so we thank you for your return engagement. I guess you didn't get scared off or get intimidated by us, so ready to come forward. Thank you. And I now recognize myself for 3 minutes for the purpose of opening and delivering an open statement. Today, our subcommittee will continue in its quest to bring about a more reasonable federal financial regulatory system. We'll have the opportunity to examine 6 bills authored by Congressman Laudermilk, Trott, Royce, Hill, and Congresswoman Tenney and myself that will better allow financial companies to serve their customers. From banks and credit unions to credit reporting agencies and attorneys, we've seen an impeded ability for businesses across the nation to offer financial services and guidance. Collectively, these bills will streamline regulatory requirements and eliminate inefficiencies that ultimately have the greatest impact on the American consumer. Included in today's hearing is H.R. 3312, My Systemic Risk Designation Improvement Act. This legislation, introduced with 5 Republicans and 5 Democrats from this committee, aims to improve the manner in which financial institutions are regulated by more closely tying the designation of systemically important financial institutions, or SIFIs, to actual risk in the financial system. My legislation replaces the inflexible, arbitrary $50 billion threshold for designation with a series of well-established standards that more accurately measure systemic importance. Specifically, this legislation requires the Federal Reserve to review an institution's size, interconnectedness, suitability, substitutability, global cross-jurisdictional activity, and complexity. An inefficient regulatory system based exclusively on arbitrary thresholds can have real economic consequences. The current SIFI standard has led to marketplace disruption and penalized companies for size alone rather than business activities and other important factors that actually impact risk. As I've said before, it's past time to demand a reasonable regulatory structure that fosters opportunity. The American people deserve economic freedom and the ability to control their own financial future. They shouldn't continue to suffer from Washington, D.C.'s top-down approach and micromanagement. I want to thank my colleagues for participating in today's hearing and for producing legislative proposals that will help revitalize the financial system. We have a distinguished panel with us today, and I look forward to your testimony. The chair now recognizes another gentleman from Missouri, Mr. Clay, the ranking member of the subcommittee, for 5 minutes for an opening statement. Mr. Clay.
Thank you. Thank you, Mr. Chairman, especially for holding this hearing to review legislative proposals intended to improve our federal financial regulatory regime. And thank you to each of the witnesses here today for providing insight on these proposals. While the 2008 financial crisis may seem like a long time ago for many, I was here when it happened, and I will never forget that we crafted the Dodd-Frank Act to ensure that this country never faces anything like that again. The financial crisis should have taught Congress to proceed very cautiously before rushing to roll back regulations. While improvements can always be made, an efficient federal financial regulatory system should not just mean less or no regulation. An efficient system is one that actually works, and by that I mean laws and regulations that should support a strong financial services sector, but they should also protect consumers and promote stable economic growth. Consumers that are harmed by wrongdoers deserve adequate compensation. Consumers making large purchases, like buying a home, deserve to be given accurate, timely, and easy-to-understand disclosures. Consumers should not be duped by misleading materials about future financial obligations or about outstanding debts. That being said, I'm concerned that many of the proposals that will be discussed today would modify or otherwise gut some key existing consumer protections in federal financial services laws that like the Fair Debt Collections Practices Act, the Fair Credit Reporting Act, and the Truth in Lending Act. So as we evaluate these proposals, I encourage my colleagues to be mindful that any efficient regulatory regime must minimize harm to consumers, and that any policies that we enact should not come at the expense of the consumers that we serve. The policies should also strengthen, not weaken, financial stability so we don't have another costly financial crisis. Because in the end, I believe that strong regulatory enforcement standards and consumer protection laws help to maintain the safety and soundness of our nation's financial institutions, as well as create economic opportunities for businesses and consumers. Thank you again to each of today's witnesses, and I yield back the balance of my time.
The gentleman yields back. With that, we recognize the gentleman from California, Mr. Royce, for 1 minute.
Thank you very much, Mr. Chairman. One of the bills before us today is my draft legislation, the Credit Services Protection Act, which will improve consumer access to credit monitoring and credit education services. CROA, the Credit Repair Organizations Act, was first enacted in '96 to combat the predatory practices of credit clinics who promise consumers they can clean up their credit, often with very exorbitant fees attached to that. Preventing fraudulent credit repair should remain the focus of this important act. The law, however, outgrew its original congressional intent. Judicial interpretation brought credit bureaus and others offering monitoring or education services under CROA's strict liability regime, and additional obstacles have frustrated consumers, including the mandated 3-business-day waiting period, which precedes access to education and credit scores and credit reports. So the draft bill before us today addresses the unintended consequences of CROA allowing the provision of credit education and identity protection services in a consumer-friendly manner with close oversight and enforcement by the FTC. So we should be promoting financial literacy and financial success, not hindering its delivery. Thank you, Mr. Chairman.
Gentleman's time has expired. With that, we recognize the gentleman from Michigan, Mr. Trott, for 1 minute.
Thank you, Mr. Chairman, for holding this important hearing on a series of bills, specifically H.R. 1849, the Practice of Law Technical Correction Act. This limited, targeted, and common-sense bill clarifies attorneys engaged in litigation should not be subject to interference by federal agencies. Americans should be very proud of our independent judiciary. In the United States, attorneys are held accountable by presiding judges, state bars, and opposing counsel. This delicate balance has served our country well for centuries. It ensures that all Americans, no matter who they are, can receive justice. We must protect this system against any attempts to tilt the scales of justice by interference with our independent judiciary. When the lawyer exclusion was eliminated in 1985, the bill's sponsor, a Democrat, noted that the intent was not to regulate lawyers in the courtroom, but to do so in the back room. My legislation clarifies this intent. The American Bar Association has endorsed H.R. 1849, calling it narrowly tailored, and confirms it will only exempt creditors' lawyers engaged in litigation activities. I ask that their letter be made part of the record, and I look forward to a robust and constructive...
Objection.
Thank you, Mr. Chairman. I look forward to a robust and constructive discussion about this bill and how we can reform the Fair Debt Act to serve its original intent. I yield back my time.
Gentleman's time has expired. With that, opening statements are finished, and we'd like to welcome our guests today. Ms. Ann Fortney, Partner Emerita, Hudson Cook, LLP. Mr. Charles Tuggle, Executive Vice President and General Counsel, First Horizon National Corporation on behalf of the American Bankers Association. Mr. Thomas Quadman, Executive Vice President, Center for Capital Markets Competitiveness, U.S. Chamber of Commerce. And Ms. Chi-Chi Wu, Staff Attorney for the National Consumer Law Center. Thank you. And before we get started here, we'd like to recognize the gentleman from Tennessee, Mr. Kustoff, for purpose of making a brief introduction of one of our distinguished guests today.
Thank you, Mr. Chairman. It's my honor this morning privilege and honor to introduce Mr. Charles Tuggle, who is joining us here to testify on behalf of the American Bankers Association. Since 2008, Charles Tuggle has served as Executive Vice President and General Counsel of First Horizon National Corporation, which is the parent company of First Tennessee Bank and FTN Financial, which is headquartered in my district in Memphis, Tennessee. In his current role, Mr. Tuggle is responsible for overseeing all legal matters for the company, which includes compliance with securities, corporate, and banking laws. Mr. Tuggle first joined FTN Financial as Chief Risk Officer in 2003. He has spent his entire career in the Memphis area, beginning for 30 years with the Baker Donaldson Law Firm as a chairman and chief executive officer, one of the most prominent law firms in our region and in the country. I've got to tell you that I've known Mr. Tuggle for many years, and I'm pleased to have him join us today to discuss these important matters that he'll be testifying about. I can think of no one more qualified as a chief legal officer for the bank than Charles Tuggle, and First Tennessee Bank has the largest asset base in the state of Tennessee. It's very important to Memphis and very important to Tennessee. Mr. Tuggle, thank you so much for being here today. I look forward to your testimony. Mr. Chairman, I yield back the remainder of my time.
Gentleman yields back. With that, I want to thank each of the witnesses again for being here today and recognize each of you for 5 minutes to give your oral presentation of your testimony. Without objection, each of your written statements will be made part of the record. Just to give you a little tutorial on our lighting system here, green means go. We have 4 minutes to speak. At the end of that, the yellow light comes on. It means you got 1 minute to sort of wrap up, finish up, and red means I've got the gavel and we may have to stop proceedings. But hopefully everybody will be within the time frames and keep it to that, and we'll be glad to extend if needed. But with that, Ms. Fortney, you're recognized for 5 minutes. Welcome.
Thank you. Excuse me. Thank you very much. I am very pleased to be here before the subcommittee and have the opportunity to testify on these bills. I have more than 40 years' experience as a lawyer in the consumer financial services field, including 8 years of service with the Federal Trade Commission. I have worked as in-house counsel at a retail creditor and later in counseling clients on compliance with consumer protection laws. My experience includes testifying before this committee on behalf of the Federal Trade Commission on the Fair Debt Collection Practices Act. I have testified in federal courts and before this committee on the Fair Credit Reporting Act, and I have worked with the FTC and congressional staff on the scope and operation of CROA, the Credit Repair Organizations Act. Thus, I have witnessed firsthand the consumer benefits and compliance challenges of each of these laws. I will discuss the 3 bills which relate to my background and experience. The Credit Services Protection Act draft bill, H.R. 1849, the Practice of Law Clarification Act of 2017, and H.R. 2359, the FCRA Liability Harmonization Act. Each of these bills involve laws that were enacted to address industry practices that cause substantial injury to consumers in the consumer financial services field. Industry representatives supported the enactment of each of these bills. In fact, CROA was enacted at the urging of the consumer credit industry. There is still universal support for these laws and for their essential protections for consumers. By and large, these laws have accomplished the purposes for which they were enacted. So what's the problem? Over the years, some courts have interpreted the laws in a manner that is inconsistent with the congressional intent and sometimes even with common sense. Let's take CROA first. It is designed to deal with credit repair. But some courts, especially the Court of Appeals for the Ninth Circuit, have said that credit repair includes any product or service that possibly helps consumers improve their credit or prevent deterioration. This would include services that millions of consumers already use, such as credit monitoring and identity protection. Not surprisingly, such a peculiar definition of credit repair has hurt the development and delivery of new and innovative products, even when studies have shown that consumers want and benefit from these services. Congressman Royce's draft bill would solve this problem by creating a regulatory framework for authorized credit service providers to offer personalized credit education and identity theft protection services under the watch of the Federal Trade Commission. Despite rhetoric to the contrary, the bill leaves intact CROA's protections against credit repair. Next, we have the court saying the practice of law by a licensed attorney filing a lawsuit on behalf of a client is debt collection and subject to the Fair Debt Collection Practices Act. No. Debt collection and the practice of law are 2 different things. And this is especially true when an attorney is filing a lawsuit on behalf of a client, is engaged in litigation. Preparing documents for litigation and communicating in connection with the litigation are very different activities from sending dunning letters and calling debtors. In addition, attorneys in litigation are subject to standards of conduct overseen by local courts and any state bar, while a debt collector is not. For these reasons, the Fair Debt Collection Practices Act originally exempted attorneys from its coverage. However, a few attorneys abused that exemption in debt collection practices, not the practice of law. Testifying on behalf of the FTC in 1985, I urged Congress to clarify the scope of the attorney exemption. Instead, Congress eliminated it. H.R. 1849 would do what the FTC suggested 32 years ago, create a narrow exemption for attorneys to the extent that they are practicing law in litigating on behalf of a client. Finally, H.R. 2359 would bring the FCRA in line with other titles of the Federal Consumer Credit Protection Act by placing a cap on class action awards and eliminating punitive damages. The FCRA was amended to provide for statutory damages for violations of the Act. The problem is that some courts, particularly the Ninth Circuit, have read willful out of the statute and allowed claims to proceed against small and large companies alike for mere technical violations where there are no damages. Time does not permit me to detail the problems of the three bills, the problems that these three bills would address, or the ways in which these bills would bring common sense and fairness into the law. For this reason, I hope your questions will enable me to provide a more complete picture of why I believe Congress should enact each of these bills. Thank you.
The lady yields back. With that, we recognize Mr. Tuggle, and he has a very high bar to attest to here as a result of that glowing introduction of Mr. Kostoff. So we look forward to your testimony, Mr. Tuggle.
Thank you, Congressman. Chairman Lutemeyer, Ranking Member Clay, and members of the subcommittee, I am Charles Tuggle, and I'm the Executive Vice President, General Counsel of First Horizon National Corporation. First Horizon is a $30 billion institution, 153 years old, headquartered in Memphis.
Mr. Tuggle, could you pull the mic closer to you that way?
Yeah,
very good. Thank you.
We have 170 bank branches in 8 states in the Southeast, and we offer a full range of banking services. Our fixed income business operates nationwide, serving banks and other financial institutions. Later this year, following receipt of regulatory approvals, we plan to merge with another Southeastern bank, increasing our assets to $40 billion and doubling our branches. I appreciate the opportunity to present the views of the ABA on several important bills. Our industry and its regulators both acknowledge that regulations have overshot their mark, imposing unintended costs on consumers, businesses, and the economy. We support congressional efforts to make common sense adjustments without compromising systemic stability. The 3 bills I will discuss today will help us meet the needs of our customers. The ABA is very supportive of H.R. 3312. It would eliminate the arbitrary dollar threshold for designation as a SIFI and instead would establish a process for identifying and regulating systemic institutions based on the nature of their business, not simply their size. Under current law, institutions over $50 billion are subject to much higher levels of regulation, regardless of the real risk they might pose to the financial system. This arbitrary size threshold has needlessly trapped many banks without any benefit to the system, handcuffing their abilities to provide needed credit and other services to their communities. For a bank like mine, soon to have $40 billion in assets, the prospect of crossing the $50 billion threshold is very troubling. It will trigger much greater expense and will be a significant drain on existing resources. The fact that we are growing means that we're successfully meeting the needs of our customers. Good business decisions should not be hijacked by arbitrary cutoffs that bear no relationship with danger to the financial system. H.R. 3312 takes an important step forward to benefit our economy. It helps tailor and focus supervisory oversight to promote safe and sound banking and to protect against systemic risk. We urge support of this legislation. The ABA also supports the Community Institution Mortgage Relief Act introduced by Representative Tenney. This bill would provide relief for smaller lenders and servicers with regard to escrow practices. Smaller institutions have an excellent track record providing high-quality mortgage servicing, even with limited staff and resources. The small scale combined with high compliance cost, makes it more expensive for smaller lenders to offer escrow services. Existing regulatory efforts to provide relief from escrow mandates have resulted in a complicated and confusing hodgepodge of requirements, which makes compliance difficult. This legislation seeks to simplify and provide some relief, goals we support. The bill could be improved to enable regulators to adjust the rules to address changing market conditions through regulation rather than hardwiring limitations and thresholds. The ABA appreciates the efforts by Representative Hill to address the many unanswered questions about liability and compliance under TRID, the complexity of the regulations, the intricacy of the TRID disclosure forms, and the infinite number of scenarios involved in mortgage finance create a situation where inadvertent mistakes in compliance are unavoidable. Without clarity on liability, lenders and investors will avoid exposure, which will reduce product choice and increase costs for borrowers. Ultimately, is the home buyer that bears the added cost and inconvenience of a cumbersome and confusing process with slower times to closing. The TRID improvement legislation is an important first step, but there are many more steps needed to provide clarity under the rules. We stand ready to work with the committee in developing further legislation. In conclusion, the ABA believes that common sense proposals are desperately needed that will make our regulatory system more efficient and effective. Doing so would free up scarce resources for banks and help regulators focus on where risks truly lie. The three bills we discussed today make significant advances. More can and needs to be done, and ABA stands ready to assist in this process.
Thank you. The gentleman yields back. Mr. Quadman, you're recognized for 5 minutes. Welcome.
Thank you, Mr. Chairman, Ranking Member Clay, members of the subcommittee, and thank you for holding this hearing today. In order for Main Street businesses to start and thrive, firms need access to a vibrant banking system, including fair and efficient consumer credit markets. Unfortunately, policies have moved away from that time-tested combination. Through an arbitrary threshold, regional banks and large community banks are under an enhanced regulatory scheme, even though those banks don't pose a contagion threat or risk or danger to U.S. financial stability. As a result, mid-sized and regional banks, which provide direct and indirect services to Main Street businesses, are forced with risk-based capital, liquidity requirements, resolution plans, and enhanced stress tests. Rather than loaning money based on merit, decisions are made for regulatory compliance. A recent Harvard Business School study has linked bank stress tests to decreased small business lending. In trying to resolve global issues, Main Street businesses were hit with the adverse consequences. Small business liquidity has dried up, the cost of capital has risen, and regulatory initiatives have created disincentives to helping the firms that drive growth. A 2016 U.S. Chamber survey of over 300 corporate financial professionals found that almost 4 in 5 were affected by changes in financial markets, 50% identified increased capital charges as an obstacle to financing and raising costs, 1/3 of businesses see the situation worsening over the next 3 years, and compared with the similar 2013 study, businesses have severely contracted the number of banks that they are using. A survey of 500 small businesses we released earlier this year in conjunction with Morning Consult found that a majority felt that access to capital has not improved over the past year. 50% of small businesses believe regulations are inhibiting lending, and 68% of businesses with less than 10 employees do not expect to take out another loan or line of credit in the next 4 years. Studies by the Federal Reserve, FDIC, and Community Reinvestment Act analysis found that small business lending in demand has not rebounded from the 2008 financial crisis. Loans at the $100,000 level have been particularly hit hard. Outdated laws or overbroad regulations have harmed consumer credit and reduced the effectiveness of consumer protections. This hurts a firm's customers, but also remember that startups use consumer financial products, credit cards, mortgages, home equity lines of credit, as the first means of financing a new business. All of this has added up to depressed business creation and economic growth rates that are persistently 30% below the historic norm. Accordingly, last year, the U.S. Chamber and 120 state and local chambers from over 30 states sent a letter to Congress asking that small, medium, and regional bank reform be a priority. This subcommittee can make that a reality. The Systemic Risk Designation Improvement Act, introduced by Chairman Luckemeyer, would regulate regional and large community banks according to their risk profile. This bill uses existing Federal Reserve standards on interconnectedness, substitutability, complexity, and cross-jurisdictional activity. Creditworthiness rather than compliance costs and stress test model will determine if a business is eligible for a loan. Those banks will be regulated, but in a smart and appropriate manner. Regulations will be aligned with the bank's activities and allow regional and large community banks to again deploy capital to Main Street in a responsible manner. The Facilitating Access to Credit Act, drafted by Representative Royce, will bring CROA into alignment with the needs of a 21st century consumer. This will allow consumers to engage in credit monitoring and help them to combat identity theft. The FCRA Liability Harmonization Act, introduced by Representative Loudermilk, will harmonize liability standards with other statutes such as the Electronic Fund Transfer Act, Fair Debt Collection Act, Equal Credit Opportunity Act, and the Truth in Lending Act. This will help ensure that consumers will be compensated for any violations and not enrich class action lawyers. The CFPB's TRID rule has caused uncertainty in mortgage markets, creating liability concerns, thus making it harder to issue mortgages to deserving customers. The TRID Improvement Act, introduced by Congressman Hill, will allow minor errors to be corrected and create a cooling-off period. This will create certainty in the marketplace, making secondary markets and the overall mortgage markets much more efficient. These three bills will help improve consumer protections and assist startups to get the capital they need. The bills before us today provide a path forward that balances stability and growth. Access to capital will be restored to Main Street businesses, and protections will be aligned with consumer needs. Thank you, and I'm happy to take any questions you may have.
Gentleman yields back. With that, we recognize Ms. Wu for 5 minutes. Welcome.
Thank you, Mr. Chairman, Ranking Member Clay, and members of the subcommittee. I appreciate you inviting me to testify today regarding the 6 bills being considered at this hearing. I'm testifying on behalf of the low-income clients of the National Consumer Law Center. We oppose each of these bills because they will harm the interests of American consumers. With respect to H.R. 2359, we are opposed because it would drastically reduce accountability for violations of the Fair Credit Reporting Act, a statute that's critical for protecting the financial reputations of ordinary Americans. To explain our opposition, I want to talk about some of the folks who've had their reputations shredded by false information in their credit reports or background checks, and whose legal recoveries would be limited by this bill. People like Angela Williams of Florida, who spent 13 years fighting with Equifax to fix her credit report, which contained at least 25 negative accounts that didn't belong to her. She was wrongfully pursued by creditors and debt collectors and repeatedly denied credit due to Equifax's systemic failures to fix the errors in her credit report. Everyday workers like Richard Williams, who was repeatedly falsely labeled a criminal by First Advantage Background Services, costing him 2 jobs, with the result that he was unemployed for most of a year and a half. And innocent Americans like Sergio Ramirez, who along with 8,000 other consumers in 49 out of 50 states were misidentified as terrorists or drug dealers in their credit reports because TransUnion confused them with similarly named individuals from a government watch list. Can you imagine the horrors that these consumers lived through, falsely being accused of being a criminal, a terrorist, or a drug dealer, or a deadbeat? To paraphrase Shakespeare, who steals my purse steals trash, but he that filches from me my good name makes me poor indeed. Supporters of this bill have suggested that the FCRA violations are merely technical. There is nothing technical about being wrongfully labeled a criminal, a terrorist, or a deadbeat. That alone causes significant trauma and harm. But the consequences go beyond that. Inaccurate credit report or criminal history information deprives consumers of the ability to get credit, employment, rental housing, and more. H.R. 2359 would deny consumers, such as Angela Williams, Richard Williams, and Sergio Ramirez, the ability to seek full accountability for the outrageous violations of the Fair Credit Reporting Act that affected their lives. It would eliminate the ability to seek punitive damages, which has been a feature of the FCRA since its original enactment in 1970. In cases such as Sergio Ramirez, where consumers have banded together in a class action to seek relief, H.R. 2359 would limit their recovery for both statutory damages and actual damages to $500,000, no matter how many thousands or millions of consumers were harmed or the extent of the losses created by the illegal conduct. Limiting the consequences for wrongdoers under the FCRA would enable credit bureaus and background check agencies to blithely disregard protections meant to ensure accurate reporting. And notably, the three major credit bureaus, Equifax, Experian, and TransUnion, are often among the three top most complained about companies to the CFPB every month, with the vast majority of complaints involving incorrect information on credit reports. We also opposed the Credit Services Protection Act of 2017, which would exempt these big three credit bureaus from CROA. The exemption is unnecessary and harmful and would remove consumer protections when credit bureaus sell credit monitoring, identity theft prevention, and other products of questionable value. Frankly, it's pretty nervy to propose this exemption, given that these products were the subject of enforcement action just this year by the CFPB for deceptive marketing practices, in which Equifax and TransUnion were ordered to pay refunds of $17.6 million plus fines of $5.5 million. And Experian was ordered to pay a fine of $3 million. Instead of being covered by CROA, the bill substitutes weaker and less enforceable provisions governing authorized credit services providers. Unlike CROA, it doesn't include prohibitions against advance fees, fails to require the clear disclosure of 3-day right to cancel, cannot be privately enforced, preempts state law and state attorney general enforcement, and could limit the CFPB's authority over credit bureaus. It could also allow illegitimate credit repair organizations to escape from CROA. Because approval is automatic after 60 days if the FTC doesn't act. Finally, we opposed the 4 other bills that are subject to the hearing for the reasons stated in my written testimony. I thank you for the opportunity to testify and look forward to your questions.
Gentle lady's time has expired. Without objection, the gentleman from Arkansas, Mr. Hill, and the gentlelady from Arizona, Ms. Sinema, are permitted to participate in today's subcommittee hearing. While not members of this subcommittee, Mr. Hill and Ms. Sinema are members of the Financial Services Committee, and we appreciate their interest and participation today. With that, the chair now turns to the gentleman, Mr. Pittenger, for 5 minutes, if he has questions.
Thank you, Mr. Chairman. Mr. Quadman, the CFPB claims that it wants to help lower and middle income consumers. Yet the Bureau's own study on class action lawsuit waivers shows an average consumers win more in arbitration versus class action lawsuits. Mr. Quadman, can you please relay to the committee what the CFPB found when they looked at the average dollar amount that consumers won in arbitration versus class action lawsuits?
Thank you for that question, Mr. Pittenger. I'm probably going to be off on the numbers just slightly, but I believe that the CFPB's own study found that with individual lawsuits, with individual complaints, consumers were reimbursed to the tune of over $5,000. Whereas with class action, it was somewhere around $30. We have actually asked the CFPB, in trying to move forward with this arbitration rule that they've recently finalized, that is actually the exact reason why you have a cost-benefit analysis, because that shows that arbitration, numbers the other way. Arbitration, people get $5,000 of compensation, and the other way around, $30 with class action. So arbitration is actually a very firm way of making sure that consumer complaints are resolved.
Yes, sir. What other benefits do you see for arbitration over class action lawsuits for consumers? And why will the CFPB's arbitration rule be so harmful?
So number one, the costs of arbitration are borne by the company. The consumer does not face any of the costs with that. And secondly, the time with getting a consumer complaint resolved through arbitration is much quicker than going into court. So it provides the benefit of giving consumers the benefit of getting their situation resolved and quickly. It also provides benefits to the taxpayer without having to clog up the court system.
Yes, sir. Thank you. Ms. Fortney, a person's credit score is so critical to their quality of life, as you well know. Even a 20-point boost can mean a cheaper car loan or a mortgage. We should do everything we can, I'm sure that you would agree, to protect access to services and products that help people improve their credit worthiness. I would like to say parenthetically that Representative Keith Ellison and I have a bill that will encourage and benefit consumers to help reestablish their credit, to utilize their mortgage payments, car payments, utility payments to help build their credit score. But, Ms. Portney, I would agree with you that the Credit Repair Organization Act protects consumers from the claims of certain bad actors who falsely say that they can fix your credit overnight. That said, you testified that the Facilitating Access to Credit Act does not jeopardize these protections. How will consumers benefit from this legislation? What is going to be the impact on folks that need some education on getting their score to a better place?
Let's put the talk on. First of all, there is nothing in the draft bill that would interfere with CROA as it stands today. CROA will still remain intact to protect consumers from credit repair organizations and the false and deceptive claims they make. Secondly, contrary to what the NCLC has said, amending CROA in the way we have discussed will not in any way jeopardize the ability of the Consumer Financial Protection Bureau or the Federal Trade Commission to pursue companies that engage in unfair or deceptive acts or practices in the offering of any products or services. The cases that Ms. Wu mentioned were all brought under UDAP statutes, not under CROA. What this bill would do is create a new framework under which companies could offer individualized consumer education services and other types of identity theft protection services to consumers without the fear that a court, particularly in the Ninth Circuit, would say, oh, that's credit repair. I have to say, I am just astonished that the courts have reached that conclusion, because to me, there's a real difference between repairing something and helping consumers deal with the credit now and in the future. You know, you take your car into the shop when it's broken to be fixed, to be repaired, but you take your car to the dealer or to a gas station to be maintained. Those are two different things. One is retroactive, the other is prospective. So the courts have really strained to find that consumer education products and services and credit monitoring are repair, and actually what they're doing is helping consumers maintain and improve their credit. And the reason we need this is today, more than ever, there are opportunities for consumers to see their credit scores and to know what's in their credit reports. The problem there, though, is that consumers say, yeah, I now know I have a low credit score. How can I fix it? How can I improve it? Right now, as interpreted by the courts, CROA prevents these companies from offering this service. What this bill would do would be create a framework under the close supervision.
Gentleman's time has expired.
Thank you, Ms. Fortney. I appreciate your great input.
Chairman now recognizes the gentleman from Missouri, Mr. Clay, for 5 minutes.
Thank you, Mr. Chairman. While Ms. Wu's written testimony provides a few examples of innocent consumers harmed by violations of the FCRA who would be adversely impacted if H.R. 2359 were enacted, another consumer advocate shared a troubling story with the committee that I would like to get each of your reactions to. And one of the major consumer reporting agencies was alerted at least 8 times over 2 years that it had mixed a consumer's credit file with a different person who had the same name and a similar Social Security number, but who lived in a different state and who had a bad credit record. Despite this, the CRA failed to correct the mistake, causing this person to be rejected for loans. The consumer eventually sued the CRA, and a jury awarded her compensatory and punitive damages. The judge in the case said, and I quote, "For 2 years, Ms. Miller was frustrated, overwhelmed, angry, depressed, humiliated, fearful about misuse of her identity and concern for her damaged reputation. Equifax engaged in reprehensible conduct that caused real harm to Ms. Miller. Equifax should be punished financially for that wrongful conduct. The punitive damages award should be enough to deter Equifax from repeating this type of conduct in the future. For each of you all, let me start with Ms. Fortney. Do you think punitive damages were appropriate in this case, and can you please explain why innocent consumers should not be entitled to receive punitive damages from wrongdoers who willfully or recklessly fail to comply with federal law? Let's start with you. Okay.
I was actually an expert witness on behalf of Equifax in this case. I am intimately familiar with the facts of that case, and I think, as you would see if you actually looked at all of the testimony in that case, there were two sides to the story. Obviously, the court and the jury took the side of the plaintiff. There were very, very unusual circumstances in that case, and I agree. This individual was entitled to actual damages if she could show, and to the extent she could show, and she did show, actual harm. What I'm concerned about is this attitude that you now need to send a message to a company that is doing everything it can to comply with the law and makes mistakes. We all make mistakes. And the whole question is, if you have the risk of punitive damages hanging over your head, you're not going to be as effective in delivering the products and services that the FCRA covers.
But the damage was to the consumer.
Yes.
That hurt that person, Ms. Fortney, not to Equifax because of their inaction. Let me go on to Mr. Tuckle. Can you respond to this case? Are you familiar with it?
I am not familiar with the case. Ranking Member Clay, I will have to tell you that my experience as a lawyer, and I've been doing this 40 years now, is that you need to know all the facts before you can evaluate a situation.
Right. That's fair enough. Mr. Quay.
Sure. Thank you, Mr. Clay. I'm not aware of the facts of the case. However, just a couple points to note. I mean, there are government agencies such as the IRS that have also misidentified consumers, and those people cannot, or it's very difficult for them to sue the government. So I think we need to take that into account. I think you also make a larger point in favor of the bill, is that it was an individual harm. That this bill is looking to harmonize FCRA with all the other different credit reporting and consumer statutes that there are to put caps on liability and class action. So I don't think that the consumer still can sue. The consumer can still recover damages and be made whole, even under the harmonization bill.
All right, Ms. Wu, do you have a response?
Yes, Julie Miller absolutely was entitled to punitive damages. The Equifax's error just caused her great trauma. She wasn't able to help her disabled brother get credit. The judge, the jury all agreed, and this bill, HR 2359, would snuff out her ability to get punitive damages. She would not have been able to get the recovery she did if this bill were in effect. Neither would all the other consumers I mentioned.
Thank you. My time has expired.
Gentleman's time has expired. Then I recognize myself for 5 minutes. I think we appreciate the comments so far, and it's interesting. You know, I think we had a great group of bills here today that actually address a lot of issues that are of concern. I know my ranking member made a comment ago about rushing to change the system, and I don't think we're rushing here after 7 years of Dodd-Frank. Any bill that we have out there needs to be fixed, tweaked. You know, some things go too far, some things go far enough, so I think it's important that we stop, take a look at a lot of these things, and try and fix some problems and inequities in our system. I appreciate Ms. Fortney's comment a minute ago with regards to rules interpretation and enforcement with regards to inconsistent with the intent and common sense of what's been going on. So hopefully that's where these bills go. I want to discuss a little bit with regards to my bill, the Systemic Risk Designation Improvement Act. Mr. Tuggle, you know, your bank is one of those banks that is getting ready to, as it grows, hit the threshold within which it's going to cost you a whole lot more money to be able to comply, to stay in business with all the extra restrictions, regulations. Can you address an issue such as, are you going to continue to try and grow and then hit that threshold and comply, or is this a deterrent to your growth and therefore you're a deterrent to continue to address the needs of your community?
Thank you, Mr. Chairman. It will be a significant issue for us in considering future growth. We'll soon be $40 billion. If our organic growth rates continued as they have been for the last few years, we'll be looking at the $50 billion threshold will within 3 years, and if we saw another merger opportunity, it could accelerate from that point. Here's the challenge. The decision that a bank like ours faces is it better for us to be a $49 billion bank or a $51 billion bank? And the answer is pretty clear. It's better to be a $49 billion bank from the perspective of expense, regulation, and effect on our company from an organizational perspective.
Okay, so the question is, when you tip over the threshold, you become a different bank? Has your business model changed? Has your risk model changed? Only thing you've done is grow $2 billion more. $2
billion.
49 to 51.
Correct.
I think, you know, the point of my bill is that we take the systemic risk calculation of the Fed and use that to determine where we go with this rather than an arbitrary figure of $50 billion. While a $50 billion bank is a nice-sized bank, it's not systemically important. Would you agree then?
I totally agree with that. I can tell you that that's a fact.
Yeah.
The issue, let me say this about our bank, and I think we are representative of many banks across the country. We are $30 billion, soon to be $40 billion, but we're essentially a community bank. You know, a community bank in our mind is a bank that takes deposits and extends credit to people in its marketplace as its predominant line of business. That's what we do. We're not complex. I would like to think we're sophisticated, but we're not complex. And we've talked about this, Mr. Chairman. I can tell you that if we were approaching $50 billion, but we were only going to go slightly over it, I don't think we would do that. And there are consequences that are adverse to our communities for doing that. If we don't continue to grow organically in particular, based on the fact that customers want to do business with us, then we're not going to be able to extend the levels of credit that our communities benefit
So basically, when you look at risk, which is what we should be looking at here, if you analyze the 5 different sets of criteria, that determines whether you're systemically, and you know, size is one of them, determines whether you're systemically important and whether your risk that you're taking, your business model that you take, that you have, is something that could bring down the economy. And that's the definition of a systemically important institution. Mr. Quadman, before we get too far here, I really appreciated some of the data that you had, some of the surveys. 50% of small businesses have difficulty with access to capital, and we saw a dramatic decrease in small business lending as a result of the SIFI situation. Banks are the mid-sized regional guys, which are addressed, basically they lend to mid-sized regional businesses, are having trouble, though those businesses are having trouble getting access to capital. Can you explain that a little bit more, go into more detail?
Sure. So the regional, mid-sized, and large community banks are, you know, they provide a lot of the small business lending. And what they also do is they're also liquidity provider to other smaller community banks that also are Main Street lenders as well. So what happens is, you know, as First Horizon or other banks are going to cross that $50 billion threshold, suddenly all the enhanced regulations and the Federal Reserve regulations that then come upon them suddenly make those small business loans unattractive because they're, you know, they're a little riskier according to the regulator or whatever. What is often forgotten is that that regional bank is going to know that customer is going to have a much better idea as to who is worthy of getting a loan and who isn't. And instead, we're seeing that it's more the compliance people, once you go over that $50 billion mark, that instead of the loan officer that start deciding who gets loans.
So instead of allowing the bank to decide its own risks, you have the regulators deciding what risk to take. Is that what you're saying?
That's correct.
Thank you very much. My time's expired. With that, we go to the distinguished gentleman from Georgia, Mr. Scott. Recognized for 5 minutes.
Thank you. First of all, I want to talk about the frivolous lawsuit situation. And let's be clear, the great value that class action lawsuits provide. Because there are, every day in the newspaper, we hear stories about abuses by our financial institutions. But Mr. Loudermilk's bill seeks to strike a delicate balance here. I think by the same token, our business community suffers from so many frivolous lawsuits that we must do something about that. And I think if there's one way of phrasing what Mr. Loudermilk's bill is doing, it's not taking away anybody's rights to class action. It is trying to come up with a balance that is fair to our financial community and our businesses, to be able to maintain class action, but to be able to put a fair balance of a $500,000 cap, of a which is standard procedure that we have with other agencies in our federal government. And so I think that as we look at this, we need to look at it with a jaundiced eye and make sure that we are doing both things, maintaining that class action right, but at the same token, being fair to those in the business area that have to work with this. Now, before my time goes out, I do want to comment on Mr. Lukemeyer and my bill. I'm proud to be a co-sponsor of this bill. I've worked with him, and my staff has worked with Mr. Lukemeyer's staff to come up with this $50 billion threshold in assets, which is something people picked up. And that's not the proper way of being able to determine what is a SIFI. These regional community banks and others should not be fed out of the same spoon as Goldman Sachs, as these other banks. They should be judged, and this is what we are doing with our bill. We've got a 5-point criterion: suitability, the competitiveness. What kind of risky behaviors are you in? Do you deal with derivatives? Do you deal with those complexities? And when you look at what the bank is doing, rather than arbitrarily taking a $50 billion threshold and laying it out there, is not the right thing to do. And it is our job as the Financial Services Committee to put out laws and legislation that are fair and that are right. And our regional banks should not be put into the same class as Goldman Sachs. Goldman Sachs is a wonderful bank. Bank of America is a wonderful bank. But they deal in cross-border. They deal in so many complex issues that they have a global impact. We should not apply that same standard to our regional banks and to those banks. So I'd like to ask two questions. First, on my first point, dealing with the with Mr. Loudermilk's bill. If Mr. Loudermilk's bill became law, panelists, how could consumers take action if they allege a violation of the law?
I'd like to respond to that, please.
Sure.
I think they would still be able to take action under the Fair Credit Reporting Act. They could sue for actual damages, and as you indicated, they could also participate in class actions. What would happen, though, is you would not have these ridiculous awards of or settlements for statutory damages for highly technical and sometimes really dubiously technical violations of the Fair Credit Reporting Act. The other thing you would not have would be the ability of courts to assess punitive damages when I think the facts do not warrant it. Ms. Wu mentioned the Ramirez case. Nobody at TransUnion or any place else said that any of the individual members of that class were terrorists. What they did was provide a copy of information from the OFAC list, which is produced by the United States Department of Treasury to deal with terrorists and money launderers. All that list says is your name happens to be the same. It doesn't say you're a terrorist. It just says you as a creditor, including an auto dealer, you must inquire further. This is a list. This is information provided by the federal government. And TransUnion was providing this as a service to the auto dealer. They weren't saying anything about the character of any of the 8,000 members of this class. There were no actual damages.
Gentleman's time's expired.
Thank you, Ms. Ford.
With that, we recognize the gentleman from Pennsylvania, Mr. Rothfuss, for 5 minutes.
Thank you, Mr. Chairman. Mr. Tuggle, I want to follow up on a couple of the points that the chairman was making about the $50 billion threshold and taking a look at the proposed legislation. Now, your bank, I understand, is approaching the $50 billion threshold, or can be very soonly.
We'll be $40 billion by year end.
If the Systemic Risk Designation Improvement Act is not enacted, that will mean that your bank will be a SIFI.
Not at 40, but we're on the way.
At 50, though, if it gets to 50.
We will.
Does your bank pose a real risk to the stability of the financial system?
In no way.
When you talked in your testimony, you talked about when you cross the $50 billion threshold, there's going to be more expense, a significant drain on resources. Have you tried to quantify that in terms of actual cost or personnel? And
we have not put specific numbers on that. Quick history, we had been working to grow for a number of years and been installing systems to accommodate growth. But let me say to you that I've recently seen some work done by RBC Capital. I don't believe this would be our expense level, but RBC Capital says that based on some peer studies it's done, it estimates that the one-time cost of just crossing from 50 to 51 are $60 to $80 million. And they estimate that the annual additional compliance cost for being a SIFI versus not a SIFI is $40 to $60 million. And then something we did look at is if you're a SIFI, you're subject to the LCR rules. In our case, in looking at just that one additional rule, we believe we would lose $15 to $20 million a year of net interest income to comply with that rule, which frankly...
So just to comply with all this added burden,
yes.
Rather than being a $50 billion bank, you might need to be a bank with much higher assets than that.
Clearly much higher assets than that.
Which raises the question that we've been seeing going on and rolling through the industry for the last 5, 6, 7 years about the consolidation going on. And that's why banks that are growing are frankly incentivized to merge and be acquired by other institutions, and we're losing a community bank or a credit union a day. If you hit that threshold or got near that threshold, would that, increase the likelihood or decrease the likelihood that you'd be looking for some kind of transaction to be able to accommodate those expenses?
Well, it would mean that we would not look at, frankly, a small acquisition that might make sense for us to add assets and opportunities in markets, because if we were at 49, adding a $2 billion bank that makes no sense at all. If we had an opportunity to add, a merger of equals, then we would be serious about that. But the consequence is, if we're at 49, and as I say, we're a community bank, we're focused on the customers in our markets and the businesses in our markets, and we do a good job of that. That's why we've been around 153 years. If we can go from 49 billion to 55 billion, then we can do more for our customers. We can extend more credit. We'll have more resources available to help them. But if the cost of that is so great that growing means we actually will have less money to spend in the form of credit and investment in technology and investment in new people, then it makes no sense at all.
And it doesn't let your customers and clients grow their businesses.
It does not.
If I could switch to Mr. Quadman, you spoke favorably in your testimony about H.R. 2359, the Fair Credit Reporting Liability Harmonization Act. Can you explain why you feel that there is a need to bring the FCRA in line with other financial consumer protection statutes?
Yeah, thank you very much, Mr. Rosas. If we take a look at it, we have a collection of consumer credit bills there, or legislation, and the FCRA is the one outlier. So this is going to make sure that the liability regimes for all of these is going to be the same. I think it's also important to note as well that when the FCRA was passed in 1970, the class action bar was not the problem that it was later on, and that Congress consciously decided to put in these liability caps moving forward. So I think it's, as we've heard here, it's creating a balance where the consumer can be made whole if there's a violation or if there's a problem, and that there can also be ways that businesses can have some certainty as well. So we believe it makes logical sense to pass the bill.
Thank you, Chairman. Yield back.
Gentleman's time has expired. With that, we go to the gentlelady from New York, Ms. Maloney, recognized for 5 minutes.
Thank you. And I first of all, I want to thank the chairman and the ranking member for this hearing and all the panelists. And I just want to put this in perspective. The reason we passed Dodd-Frank was that we had a financial crisis that resulted in the loss of $15 trillion in wealth for families. People lost their jobs, their homes, their pensions, and that the root of this crisis was abuse of consumers. The Bureau of Labor Statistics and other economists came out and said this was the first financial crisis that was totally caused by mismanagement. Yet since we passed Dodd-Frank under the Obama administration and continuing now under the Trump administration, this country's economy has created more than 16 million private sector jobs. That's absolutely great news. And business lending has increased 75% since Dodd-Frank was enacted into law. And our banks, both large and small, are continuing to post record profits, and are, at least in my district, my credit unions are expanding their membership. So this is a good news about the American economy. We've bounded back. And I question any attempts to reduce protections for consumers. And I would say that, and if I may quote Chairwoman Yellen, whom I hope President Trump will reappoint, and I quote, "Although many small banks failed because of the weak regulatory system, Dodd-Frank was designed to combat the problems that triggered the financial crisis and methodically implemented in a tiered and tailored manner so that only the largest financial firms have to comply with the bulk of new regulations. As such, the law has helped to level the playing field for smaller-sized firms, including consumer banks and regional banks, while better protecting consumers and the broader economy." So I did want to mention that since the economy's bounded back and our banks are doing well, thank God, employing people and getting loans out. But I have a series of questions, and I'd like first to ask Ms. Wu. You said in your testimony the Credit Service Protections Act would eliminate some of the CFP's authority over credit bureaus. I'd like you to elaborate on this, and specifically, it was my understanding that the CFPB doesn't currently enforce the Credit Repair Organization Act. Does this bill change this in any way?
Thank you for the question, Congresswoman Maloney. The bill what the bill says is that the FTC is the only entity that can enforce CROA with respect to authorized credit service providers, including credit bureaus. And so it could be interpreted to limit the CFPB's authority, even under its UDAP authority, when it goes after the credit bureaus for products that are covered under the authorized credit services designation. It also says the authorized credit services provisions are only enforceable by the FTC, not by the consumer, not by the CFPB. Also, just really quickly on the systemic risk bill, I'm in complete agreement, we're in complete agreement with what you said, and we just like to point out that this legislation not only reverses Dodd-Frank, it goes further by putting unprecedented constraints on the Federal Reserve, and that some of the banks that this legislation would have affected were similar to the ones that caused the financial crisis, such as Countrywide, Washington Mutual, Wachovia, and IndyMac.
Okay, also my time's running out, but you said in your testimony that security freezes mandated by state law for identity theft are actually more effective than identity theft prevention products sold by credit bureaus. And why is this? And are security freezes all that we need to prevent identity from being stolen from our constituents and our residents?
Thank you, Congressman Maloney, for the question. Absolutely, security freezes are the best identity theft prevention measure. It locks down the report so the thief can't apply for new credit using the consumer's credit report. Credit monitoring is sort of, closing the barn door after the horse has left. It detects the fraud after it happens. And so we've always said the best thing should be freezes, and that these subscription credit monitoring products are not great value.
Well, my time has expired. I have other questions. I'll submit it to the record. Thank you again, all of you, for your service. And I particularly would like to hear Ms. Fortney, but my time's up, whether or not you agree with Ms. Wu on the interpretation of the Credit Services Protection Act.
I do not, but our time is up.
Okay. All right.
Gentlelady's time has expired. With that, we go to the gentleman from California, Mr. Royce, recognized for 5 minutes.
Well, thank you, Mr. Chairman. I think Congresswoman Maloney made a point there. Perhaps I could ask on my time, Ms. Fortney, would you respond to the Congresswoman's question then?
I would be glad to. The Consumer Financial Protection Bureau has brought actions under its authority to deal with unfair or deceptive acts or practices. There is nothing in the Royce bill that addresses that at all that would interfere with that in any way. What the bill would do would simply let the FTC and consumers pursue the rights of consumers, the protections of consumers under the Credit Repair Organization Act. It does not in any way interfere with the ability of the CFPB to enforce the law.
Thank you, and thank you, Mr. Chairman.
Yeah, thank you. And I'll continue with another point here. CROA is a law that protects consumers from the predatory practices of credit repair organizations. It does this by requiring written contracts, statutory disclosures, a cooling off period, a prohibition on prepayment. Under what we're doing here with the Credit Services Protection Act, what we propose is leaving CROA in place for credit repair while changing the regulatory regime for what? For credit education. That's the point. We've tried to strike the right balance. On one hand, offering a clear path to better financial literacy for consumers while maintaining the strong consumer protection by the FTC, by the CFPB, and by the state attorneys generals. So how would consumers continue to be protected under this provision? Can the bad actors that offer predatory forms of credit repair simply use this law to escape CROA liability? No, but I will ask Mrs. Fortney if she wanted to.
I would be glad to, because that's one of the misconceptions about this bill, that somehow companies that actually engage in credit repair could use this framework, this regulatory framework within the Federal Trade Commission to evade compliance with CROA. Actually, in order to be certified, to be registered as an authorized credit services provider, there has to be a determination by the Federal Trade Commission that you don't engage in credit repair. And I can say that there is no agency or entity in America that is better qualified to determine whether somebody is engaging in credit repair or not. The FTC has successfully and vigorously enforced CROA for the last 20 years. What this bill does is create a separate regime, a separate framework under the supervision of the Federal Trade Commission. And one of the objections was that somehow credit repair organizations would apply en masse. I think it would take the FTC 5 minutes to determine if somebody is in fact a credit repair organization or if somebody is an entity that actually wants to provide individualized consumer education, products and services, and identity theft protection services. The FTC would very carefully review the qualifications and the business of each of these entities. It would require a 3-day cancellation period. It would require a notice. And I think there's concern also about whether this notice would be clear and conspicuous. You know, the FTC has developed the standards for what's clear and conspicuous. They're going to know if the notice is clear and conspicuous. These companies that want to be authorized service providers would, in fact, subject themselves to very close scrutiny by the FTC. I think this would enhance the protections for consumers with respect to credit education and identity theft protection products.
And I'll throw another point out here for Mr. Quadman, because your members provide credit to millions of Americans that want to buy a house or a car or finance education and so forth. So in previous testimony, we heard from the Economic Research Council, personalized credit education materially benefits consumers, and 23% of consumers improved and moved up score bands such as from subprime to near prime or to prime after receiving personalized credit education from a National Credit Bureau. What then does access to credit education mean for consumers from your standpoint here?
No, Mr. Royce, I think you're exactly along the right lines that, consumers are much more savvy and understand that they need to stay on top of their credit scores and be much more aware of what is impacting their financial situation. So to the extent that we can help educate consumers to be better informed and to better use tools to protect their credit scores, they're going to be not only better consumers, they're going to be better entrance into the financial
Thank you, Mr.
system.
Chairman. Mr. Chairman, if I could ask unanimous consent to submit for the record 9 letters of support for my draft legislation, including from the Coalition to Improve Credit Education, the National Black Caucus of State Legislators, the National Bankers Association, the Policy and Economic Research Council, the U.S. Chamber of Commerce, and the U.S. Hispanic Chamber of Commerce.
Without objection.
Thank you.
The gentleman's time has expired. We now recognize Ms. Velasquez, the gentlelady from New York, for 5 minutes.
Thank you, Mr. Chairman. Mr. Toggle, the Systemic Risk Designation Improvement Act removes Dodd-Frank's $50 billion asset threshold to designate a firm a SIFI and replace it with an indicator-based approach. There are a number of important factors to consider before making such a critical change. But as you know, regional banks are the primary lenders to small and medium-sized businesses. And as the ranking member on the House Small Business Committee, I am always concerned about access to capital for small businesses. You claim, or your argument in support of this change is that the cost of compliance hinders your ability of your banks to lend and to increase access to capital for small businesses and consumers. So I would like to know what specific tangible steps will you be taking to increase access to capital? You just stated in one of your answers that it costs your bank between $40 to $60 million to be designated a SIFI. I see here that in 2014, you made 2,337 loans to small and medium-sized businesses in the amount of $5 million. If we make this change, how will that amount will change?
Thank you. One point of clarification, Congresswoman. What I said was that RBC Capital had done a study, and that's what they thought the numbers would be. That's not a number that we've identified. Let me say—
But when you cited the study, is to basically back up your argument of the costs of compliance.
That's correct.
Yes.
Yes. Yes. So we do lend to small businesses. I'm not familiar with the number that you just talked about. I can tell you that—
You got it from your website.
That's fine. I'm not questioning it. I'm just not familiar with it. I will say that we received our CRA lending rating from the Fed for the years 2010 to 2013 recently, and we were rated high satisfactory on our lending component. So I think we really do work hard to identify opportunities and make loans. Let me say that we have significantly expanded our focus on CRA lending, which often includes small businesses, and we have submitted plans to show that we are going to lend more, that we are going to invest more in our communities. So I'm very comfortable with our real commitment to small businesses in the communities where we bank.
Well, for the bank that is, you have in assets $40 billion?
30 today.
Yes, and $5 million to small businesses. You know, that's— I just would like to know how that figure will change dramatically if such a change will happen.
Well, I can't give you a number today. Again, I can tell you that that we have really focused in the last 2 years on CRA, and CRA does expect significant lending to low to moderate income people and small businesses, and we have made significant increase.
I hear you about CRA, but I also hear small and medium-sized banks or regional banks making the argument that you are the one that lend to small businesses, right?
Yes.
So I just want to make sure that such a change happens. How would you specifically take the kind of steps that will increase access to worthy small businesses? And then we may, we heard Carolyn Maloney stating the fact that that increase in lending that lending to small businesses has increased by 75%. Ms. Forney, regarding the discussion draft of the Credit Services Protection Act, I am concerned that consumers may be subject to abusive marketing and business practices by providers of these services. How can we be assured that the FTC will have full authority to protect these consumers?
Thank you. They will have the FTC does have authority to protect consumers from unfair, deceptive acts or practices. And as I said, I think what's really significant here is that the companies that would subject themselves to this framework, this regulatory framework, and continued oversight by the Federal Trade Commission are companies that recognize that the FTC will be watching what they do in terms of advertising, and if they happen to engage in any practices that the FTC finds to be in violation of the registration or unfair, deceptive acts or practices, the FTC can and will enforce them, enforce the law.
Lady's time has expired. With that, we go to the gentleman from Colorado, Mr. Tipton. He's recognized for 5 minutes.
Thank you, Mr. Chairman. I'd like to thank the panel for taking time to be able to be here in your testimony. Would like to note I appreciated Mr. Scott's comments in regards to H.R. 2359 when he did note the frivolous lawsuits and the need to be able to seek a fair balance, and certainly appreciate the hard work of our colleague, Mr. Laudermilk, in regards to this legislation. Ms. Fortney and Mr. Quadman, would like you to maybe be able to expand on maybe a little broader sense in regards to FCRA. Criticism that we've heard of this bill is that it would reduce accountability for credit bureaus and labeling innocent consumers wrongfully. However, large class action lawsuits have also been targeting not just the credit reporting agencies, but have also expanded to a number of other businesses as well. If you could expand on me, perhaps, for how does the broad range of businesses that are subject to FCRA, including medical record agencies, check verification companies as an example, broaden the statute's governance just beyond credit bureaus and what the impacts are?
Thank you. I think we first need to understand two things about the Fair Credit Reporting Act. First, the scope. As you indicated, it applies not just to credit bureaus, but to other companies that are consumer reporting agencies. It also applies to users of consumer reports, creditors, retailers, employers. And so it is a statute that is very broad in its scope. It is also a very, very detailed and complex statute. I worked with that statute for 40 years, and I can tell you, it is what the United States Supreme Court characterized it to be, which is less than pellucid. This is a situation where reasonable people can disagree as to the interpretation of the statute. And then we have the situation now where there are these class actions based on hyper-technical violations of the Act, where the company, let's say an employer, actually provides the notice that's required to a consumer, to an applicant or an employee, that they're going to obtain a credit report. They provide it to them on a piece of paper. Unfortunately, the courts have said, well, that piece of paper had something else on it. Not that piece of paper, or what was on the piece of paper, detracted in any way from the notice. So you have a very, very technical violation of the Act. No actual damages. And that's the problem. So many of these lawsuits involve no actual damages, and they are brought in order to obtain these unlimited statutory damages in class actions. And the range of this act, the complexity of the act, is the reason why we need relief in this area.
Mr. Tipton, thank you for the question. As you noted, employers do use consumer reports in doing background checks in the hiring process. So if there is a violation there, it is generally it's a very technical violation and it's an individual issue. However, what we've seen is FCRA class actions filed against businesses ranging from fast food restaurants, grocers, retailers, universities, and transportation companies. So, if we were looking at highly technical individual problems, they could still be addressed under the harmonization bill, but what we're talking about here is not a class, but an individual problem, and this bill addresses that.
And I think it is important to note, everyone wants to make sure that consumers do have access to recourse if they have actually been harmed, but I think it is going to be important for us is this piece of legislation. Is this going to impair the ability of consumers to be able to protect themselves from false or inaccurate information? Are they going to be impaired? Do they have access?
I'm sorry, I do not believe they will be impaired in any way. The Act already provides for a lot of mechanisms that consumers have to protect themselves. They can see information in their credit reports. They can have that information verified. They can have the information removed if it can't be verified or it's inaccurate, and they can do all that for free. The Act has many, many protections for consumers. So I don't think that it will be that the protections of the Act will be impaired. As you note, there will continue to be the right of consumers to sue for violations of the Act. What there will not be will be the risk of draconian civil penalties or statutory penalties for technical violations of the Act or for violations of the Act that were not willful. When the courts decides, well, I disagreed with the interpretation, therefore it's willful. That is reading willful out of the statute, but unfortunately courts, and particularly the Ninth Circuit, have done that.
Thank you, Mr. Chairman. My time's expired. Appreciate it, panel.
Gentleman's time has expired. With that, we go to the gentleman from Texas. Mr. Williams, recognized for 5 minutes.
Thank you, Mr. Chairman, to all of the witnesses for your important testimony this morning. As a small business owner and in full disclosure, a car dealer for 47 years in Texas, I understand the importance of credit and the impact it can have on everyday life, and I'm still in the business. In fact, some of the most important milestones in one's life can be dictated by their credit. Whether it's buying the first family home or finally purchasing the car they want, individual credit is a key difference maker, and it's for all the supply chain. Now, Dodd-Frank's a disaster, and for this reason, amongst many others, I'm concerned that unnecessary regulations threaten to harm the endeavors of hardworking Americans on their path to fulfilling their dreams. And this idea of hiring more compliance officers and loan officers, we need to probably stop that. I'm encouraged by this committee's continuous work to improve the financial health of consumers across the country through deregulation and relief from unnecessary government encroachment. So last Congress, I was proud to co-sponsor the Facilitating Fair Access to Credit Act that would exempt certain credit reporting agencies, CRA, from the requirements of the Credit Repair Organizations Act, CROA. One of the largest barriers under CROA is the 3-business-day waiting period for consumers to utilize credit education services. So, Mr. Quadman, can you speak on the importance of credit education services? You've done that earlier, and how lifting the 3-day waiting period could assist consumers in making better informed decisions.
Yeah, thank you, Mr. Williams, for that question, and also to reiterate on the points that Mr. Royce was making earlier, that the CROA protections are going to remain in place against predatory organizations. The reason why the 3-day, I think we have to look at it in this way, right? When CROA was passed in 1996, we didn't have iPhones. So it is much easier and quicker for consumers to access information and to stay on top of their credit histories, et cetera. So I think the 3-day cooling off period actually inhibits communications that can be beneficial to consumers in terms of receiving education and other communications that can help them. So I think we need to adjust the legislation to reflect the realities of the consumer needs as well as the delivery devices that currently exist.
Thank you. Ms. Fortney, regarding the Credit Services Protection Act, I was a co-sponsor in the last Congress of the of the earlier iteration, because I think it's important that consumers are able to obtain individualized credit education from responsible entities. Is there evidence consumers would benefit from innovative credit education products?
Yes, there is. There are studies that are cited to and linked in my written testimony that show that consumers want and benefit from these services, that they are, in fact, able to improve their credit. They are able to understand much better what is in their credit score, how to improve their credit score, how to deal with their credit histories. So actually what these companies want to do is offer services that help consumers improve their credit. The problem is the interpretation of CROA prevents them from doing that. So what we have here is a framework under the supervision of the FTC that would enable consumers to get what they want. And the studies show this is what they want and need.
Thank you. Mr. Tuggle, any relation to the Tuggle in Killeen, Texas? It's the banker?
Not that I know of.
Okay. In the closing of your testimony, you stated ABA believes that common sense proposals are desperately needed that will make our regulatory system more efficient and effective. I wholeheartedly agree with this assessment. Plain and simple, is the federal government to include the CFPB acting in a common sense way? And what specifically do you believe requires immediate action?
This may surprise you a little bit. You know, we are regulated by the OCC and the Fed primarily. We've only had the CFPB in one time in our bank, and that was uneventful. So that's not something we've got real experience with. I would say that candidly, the regulators, and this is my opinion, just my opinion, I think the regulators have been under a lot of pressure to be pretty tough. And I'm not sure that in all occasions the approach was consistent with what the topic and issue was. And so I will also say that I have seen, literally seen, what we believe is a healthier relationship with our regulators recently. And that's important. Our regulators assure safety and soundness, but we need to be able to do business. So I don't want to really go too far here about the regulators, but I will say that when I look at what, candidly, the law requires of us post-Dodd-Frank, there are places where it makes no sense at all, and if the question is that overreaching? It clearly is.
Thank you for your testimony. I yield back.
Gentleman's time has expired. With that, we go to the gentleman from Minnesota. Mr. Ellison is recognized for 5 minutes.
Thank you, Mr. Chairman and Ranking Member. Ms. Wu, allow me to ask you about a bill called the TRID Improvement Act. You familiar with it?
Yes, it's one of the bills before this hearing, the committee on this hearing.
Do you know of examples of homebuyers paying strange and unexpected fees as part of their closing costs?
Oh, absolutely. We've even seen examples of a fee to email documents.
And do you know of examples of homebuyers being referred by a retailer to a title agent, a lender, home warranty service, et cetera, that provide a kickback, an affiliation, or some kind of financial benefit for the referral?
Kickbacks are certainly an issue, and I don't have case citations, but I believe the CFPB and before that HUD had taken action against settlement service providers for kickbacks.
How likely is it that a homebuyer will find out about these overcharges, referral fees, kickbacks?
The ordinary homebuyer, it's probably very hard for them to figure that out.
So it's pretty rare.
Rarely, yeah.
Hard to discover and rare to be discovered.
Yeah.
So let's say someone gets a mortgage and finds out later that the lender also charged them for property insurance or life insurance or opened up a bank account or credit card in their name without their permission. What would happen under current law?
Well, it depends on the type of charge. I mean, you know, in some cases they might be entitled to a refund, some cases actual damages, other cases statutory damages, other cases no remedies.
And what would happen if there was an accounting mistake in the closing disclosure form?
Well, so right now the situation is that once the error is discovered by the creditor or the regulator, they have 60 days to fix it. And if they fix it in 60 days, there's actually no liability.
Okay. And under current law, how would the error get discovered? Would it be the borrower, the regulator, through a lawsuit?
It could be any of those.
Most likely avenue?
Just any of them,
vary.
yeah.
And if a lender found an error, what penalties would they pay? Out-of-pocket costs to the borrower, a fine, what would be their hit?
So if they fix it within 60 days, there are none of that. After the 60 days, then yeah, there could be refunds or penalties.
Right. So under the proposed TRID Improvement Act before us today, the error correction time frame is expanded from 60 days from discovery, 2 months, to 210 days, 7 months. Am I reading the bill right?
Yeah, I mean, that's our reading of the bill too, and it's a significant extension of that time period.
So if a lender makes a mistake or an error under the bill before us today, lenders will have 7 months to correct it without any liability, is that right?
7 months, yeah.
In my read of the text of the bill, the language is designed to prevent any administrative action by the Consumer Financial Protection Bureau. This bill gives the creditor the ability to simply say, oops, after being caught or not having any penalty for making that mistake.
Yeah.
Is that right? And am I right that under this bill, any penalty assessed for errors is limited to out-of-pocket costs for the borrower?
Yeah.
And so in other words, if you get caught by fleecing a consumer, you wouldn't have to put the money you take to, you could get away with it, essentially.
It certainly gives less incentive for the lender to fix things and to fix it quickly.
So let me ask you how this 7-month review time interacts with a 1-year oversight period for the Real Estate Resettlement Procedures Act, or RESPA. Does giving the creditors or assignees 210 days instead of 60 days to run out the clock on the 365 days to pursue RESPA violations?
So I'm assuming you're talking about the statute of limitations, and yeah, so what would happen is, there would be 7 months for the lender to fix the error, and then a much shorter time period of 5 months between the end of that and the running of the statute of limitations when you couldn't file a lawsuit after.
Right. So in light of what you shared about overcharges, kickbacks, and stuff like that, should we keep the pressure on lenders to regularly review their work for errors and correct mistakes?
Absolutely.
Should we reduce the pressure on them to be excellent and honest in the work that they do?
No, I mean, incentives, as we've learned, being a consumer advocate for 15 years is very important. And that's why things like the penalties or the statutory and actual damages are important both in RESPA as well as the Fair Credit Reporting Act. You reduce punitive damages, you reduce statutory damages, you increase these periods for cure, and you reduce incentives to get it right.
So I'm not in favor of the bill because I think it's bad for consumers, and I think the power and the authority and the reason to know how to get it right is really on the lender. So I plan to oppose it. Thank you for your testimony. I think I'm over time.
Thank you.
All right.
Jumping yields back, that would go to the gentleman from Michigan, Mr. Trott, recognized for 5 minutes.
Thank you, Mr. Chairman. I want to thank the panel for being here today. Ms. Fortney, I want to talk about H.R. 1849. So Ms. Wu, in her testimony, written testimony, said that 1849 would eradicate essential protections against abusive and deceptive debt collection practices by collection attorneys. So let's use a hypothetical to try and illustrate what 1849 does and doesn't do. And I want to start with two assumptions. Let's assume 1849 is signed into law, and let's assume Visa has hired you to collect on a $1,000 unsecured debt. So you start by sending some demand letters and calling the debtor, Mrs. Smith. Would you be subject to the Fair Debt Act?
Absolutely. I would be engaging in collecting the debt on behalf of the creditor.
Let's say you started contacting Mrs. Smith before you sent out the 1692G letter. Would you be subject to liability under Fair Debt?
Yes, I would. Yes, I would.
Let's assume that your 1692G letter didn't contain the mini Miranda warning. Would you be subject to liability?
Yes, I could be.
Let's assume when you sent out the 1692G letter, Ms. Smith called up and contested the debt, but you continued to call her. Would you be subject to liability under Fair Debt, even if 1849 was enacted?
Yes.
Let's assume you're one of those bad collection attorneys, and you call up Mrs. Smith at 2 in the morning, and you say, I have Toto, your dog. You're never going to see him again unless you pay Visa the money you owe them. Would you be subject to a lawsuit under the Fair Debt Collection Practices Act?
You should be. Yes. And you should be.
You could be sued.
Yes.
Let's assume that Mrs. Smith never responds, never pays. You file a complaint and summons. And you file the complaint, and Mrs. Smith contests the debt by filing an answer saying it's not correct. And let's say the judge or the client says to you, we don't want to try this case. This is now a contested matter. Contact Mrs. Smith and say, we'll take $300 to settle this. Could you do that with certainty, knowing that without 1849 that you wouldn't be sued under fair debt?
That's the problem. The problem is you would not know with certainty you would not be sued. And the reason is you would be communicating with the consumer to collect a debt. However, you would be doing so in the context of litigation.
Right. And isn't that why Justice Kennedy in the Germain case said that that interpretation of the Fair Debt Act distorts the legal process, basically subjecting the lawyer to putting them in a position where their own personal financial interest in their bar license undermines the attorney-client relationship? Isn't that the problem we're trying to address here with the technical correction?
That is exactly the problem, and it's a technical correction that is very, very narrowly tailored to deal with the practice of law and only the practice of law in litigation.
Let's assume your complaint misstated the debt. Without 1849, couldn't you be sued under fair debt for filing a complaint that misstated the debt, maybe misstated the late charges, because an argument can be made that that is misleading to the least sophisticated consumer?
And that is a problem, yes.
And that's created a cottage industry for plaintiffs' lawyers, hasn't it?
Unfortunately, it has.
Okay. What would happen if you were the same bad lawyer and you're in court now and you called up and said, you know, we got Toto, the dog? What would the judge do? What would the State Grievance Commission do? What would opposing counsel do?
Well, I think all three of them would take action to be sure that you would be sanctioned in some way for such an egregious act.
Could be disbarred, couldn't you?
Yes, you could be.
So Ms. Wu in her testimony says that 1849 will hurt consumers, especially people who have recently lost jobs, had a death in the family, or suffered another type of devastating personal loss. And to support this conclusion, she argues that prior to 1986, that lawyers could circumvent the Fair Debt Act by hiding behind their bar licenses, and to enact 1849, this would turn back the clock on these important protections. Isn't that a total misunderstanding of what this bill does?
It's a complete misunderstanding, and it also mischaracterizes what the Federal Trade Commission was saying in the testimony I delivered on behalf of the Commission in 1985.
Thank you. I yield back my time.
Gentleman yields back. With that, we go to the gentleman from Georgia. Mr. Loudermilk is recognized for 5 minutes.
Well, thank you, Mr. Chairman, and I appreciate you having this hearing, and especially your leadership on this subcommittee and bringing forward bills that I believe are common sense and actually seek to open up and pave the path of prosperity for all Americans, not just a selected class of Americans. And that's what my staff has been working on since I've been here, is what are the things that we can do that fairly benefit everybody. And especially want to address my bill, and I appreciate my friend and colleague from Georgia, Mr. Scott, in his comments, because what the Fair Credit Reporting Act, Liability Harmonization Act seeks to do is strike a fair balance that is just like every other financial services consumer protection act that we have already on the books. And so I think it's important that we parse out facts from fiction, because we've heard a lot of stories in here and a lot of heart-tweaking testimony, but we need to parse out what's fact and what's fiction. And I appreciate Ms. Wu's testimony, especially, you can tell she's very passionate in there. But Mr. Chairman, of the instances that she brought up in here, there is absolutely no way that this bill, if it would pass, would have restricted any of those from receiving damages. It would not restrict any of those from receiving actual damages, because they were individual lawsuits, and my bill does not address individual lawsuits whatsoever. It addresses the class action lawsuit, and they would have been, they had the ability to receive full compensation for damages and the legal expenses that were involved. So we need to make sure that that is understood. And it also, if they would have been purposely violated, they would have been able to receive all of the damages that they've received. Let's also look at some other issues. The CFPB complaints. Yes, the CFPB complaints against the credit bureaus are larger. Why? Because of the pure volume of people that the credit bureaus work for. It's basically every American. That's why you're going to see a higher volume, simply because of the number of people that they support. It's also been presented that this is a Credit Bureau Protection Act, and this is false. Mr. Chairman, I have 3 letters here I would like to present for the record. One from the National Association of Professional Background Screeners, National Credit Union Association, and the U.S. Chamber of Commerce, that is also supported by the American Financial Services Association, Community Bankers Association, Consumer Data Industry Association, Electronic Transactions Association, National Association of Professional Background Screeners, Retail Industry Leaders Association, Society for Human Resource Management Software, and Information Industry Association, U.S. Chamber Institute for Legal Reform, and U.S. Chamber of Commerce. Mr. Chairman.
I'll let you take a breath without objection.
Well, this is to illustrate the vast support that this has. The other thing is that this is a draconian measure. This only aligns it with other acts that are already in place. And the final thing is we have trying to build this that we have to protect the consumer against the evil corporation out there that seeks to build its profit on the backs of the consumer. Let me tell 2 quick stories here. One is we have a business in my district that I met with last week, and they also have an operation in Corpus Christi, Texas. They are writing a $100,000 check to every employee to rebuild their homes. I have another business in my district called Home Depot. I've worked in search and recovery for years. We have a devastating hurricane coming up toward Georgia right now. Home Depot is the go-to organization that provides tarps and emergency supplies for free to help people who are damaged. Now, how does this hurt? Let's talk about a real instance. Home Depot was sued by a class action lawsuit because of a technical violation of the Fair Credit Reporting Act. Now, they settled out of court for $3 million, and even the plaintiff said, had this gone to court, they would have had a very difficult time even proving that there were damages because there weren't any damages. The consumers who didn't even know that there was a violation received about $15 apiece, but guess who got $1 million out of it? The trial attorneys who filed the class action lawsuit. Who does that hurt? That's $3 million that Home Depot does not have now to send tarps and plywood and emergency supplies to those who are devastated by natural disasters or help their employees or keep prices to their consumers low. Mr. Chairman, I know I've used up my time here, but I thank you for bringing this bill forward. This is to protect consumers and all Americans. And I thank you, and I yield back the balance of my time.
We thank the gentleman for his patience and yield back his time.
Sure.
With that, we recognize the ranking member for a letter to be entered into the record.
Thank you, Mr. Chairman. I ask unanimous consent to statements we have from AFR, Better Markets, NCLC, NACA, U.S. PIRG, and other organizations providing valuable comments on the bills we are discussing today be made part of the hearing record.
Without objection.
Thank you.
We continue our questions. We recognize the gentleman from Tennessee, Mr. Kustoff, for 5 minutes.
Thank you, Mr. Chairman, and we do appreciate the witnesses appearing this morning. Mr. Quadman, in your testimony and in your written statement, you cite statistics for the lack of loan growth going back to the time of the start of the end of the financial crisis, 2008 to 2015, or ending in 2015. Some of the statistics are really troublesome. The loan growth or the lack of loan growth from that period for loans of all sizes. Is that because the economy is growing or not growing? And what are some of the reasons that you would cite as the reason for the decline in loan growth for those types of loans?
Well, let me take the second part first. Part of the reason why you don't see the loan growth, and this is why I actually cited the $100,000 number, because we've not only have seen that with some of the studies, but in all the travels I've done around the country and talking with bankers and talking with small businesses, what you hear consistently is that the regulatory costs and burdens for writing a $100,000 loan are the same as a $1 million loan. So if you're a bank, you're going to write a $1 million loan, not that small a loan. So then when you start to drill down and you look at those employees with those firms with 10 employees and less, they're the ones who are saying, we know we're not getting a loan. So while there might be demand there, they know they're not going to get it because of these regulatory problems, so they're not even going to ask for the loan. The reason why, now to get to your first point, it's a little bit of a chicken and the egg thing. Those smaller businesses are the ones that drive growth, because if you're a startup in the garage, you're that firm with less than 10 employees, and you're sort of looking how you can get money. So if we're going to shut down, right, if you can't, with some of the issues with TRID, you can't get a mortgage or whatever, you can't get started, or you can't get that bank loan, you're not going to start that firm. And when you take a look at the Census Bureau statistics and some of the other studies we've cited, business creation is at historic lows. And we have not seen the ratio pop back in the way that it was, where you have business creation and business destruction, and that has an add-on effect because that creates a drag on economic growth.
And as far as the financial institution's ability to make those loans.
Correct. Right, and and the problem that when you hit that SIFI threshold, you have all the enhanced requirements. We're seeing that business lending tracks stress tests. We've heard that from companies, not only from that Harvard Business School study that I mentioned, and you also have situations too when you see that banks are getting close to that $50 billion number. They start making decisions that they're not growing anymore, that they're going to be lending less. I mean, I heard what Ms. Maloney said, but New York Community Bank in New York wasn't able to make a merger. So they're trying to stay below that $50 billion number. And then if you do get over that number with LCR, as Mr. Tuggle raised, suddenly business cash deposits, which are why banking started in the Western world in the Renaissance, they're now counted against your LCR. So banks are disincentivized from even wanting to take business cash deposits.
Thank you very much, Mr. Quabbin. Mr. Tuggle, in relation to the questions that Chairman Lukemeyer asked of you about the SIFI proposed legislation, and I mentioned in my remarks when I introduced you that you are the largest bank in Tennessee by asset size, and certainly in my district. If you look at Tennessee, you've got a number of metropolitan areas, but you've got a lot of rural areas across the state, and certainly the western part of Tennessee where First Tennessee is based. As First Tennessee or First Horizon now seeks to expand with your merger and go from 30 million to 40 million, and hopefully through growth, you would like to get to 50 billion or more. Can you describe, from the bank standpoint, the impact that SIFI designation, if you hit it, would affect those consumers in more rural areas of Tennessee that the bank serves?
Sure. Well, it's pretty straightforward, Congressman. It's simply a matter of, with the levels of increased expense that we will incur, there's simply going to be less available credit for us. With the increased levels of expense we incur, there'll be less investment in products and services and technology that allow us to deliver credit and other services to people wherever they're located. Technology is an absolutely critical issue for banks like ours, and we need to invest in technology to remain competitive. It's my understanding that J.P. Morgan has an annual budget of $9 billion to invest in technology. We obviously can't fund those sorts of things, but we have to fund a level of technology that allows us to be competitive, and that does go to our ability to deliver services outside the metropolitan areas.
Thank you, Mr. Tuggle. I yield back my time.
Gentleman's time has expired. With that, we go to the gentlelady from Utah. Ms. Love is recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you, everyone, for being here. I very much appreciate the opportunity to talk about the Chairman's bill, H.R. 3312, regarding the appropriate circumstances for systemic risk designation, which, of course, is an important issue that we've been trying to address for some time. Salt Lake City, Utah, is home to one of the smallest institutions that has fallen into the SIFI designation, Zions Bank Corporation, a $65 billion bank holding company. Zions Bank Corporation operates bank primarily throughout 11 Western states and is focused on traditional banking models, taking deposits, making loans, providing high level of customer service. Zions Bank's CEO, Harris Simmons, has testified before this committee and the Senate committee about the cost and the challenges that have been imposed on this institution as a result of the SIFI designation. According to Mr. Simmons, as a result of the enhanced prudential standards requirements of Dodd-Frank, Zions has had to divert resources to add nearly 500 additional full-time equivalent staff in areas that deal with just compliance, internal audit, credit administration, and enterprise risk management. Mr. Simmons went on to testify that Zions had to move resources away from lending and consumer services because of those regulations. So I just want to make a quick comment about what we're talking about when we remove these services. We're talking about people not being able to have access to the services that they need. We're talking about people that live in Sanpete or Juab County that are trying to run their farms and can't get the equipment that they need to be able to do that. They can't get the loan or the services because all of those funds and the resources have been diverted to something else. Let's be clear about what we're talking about. When we add cost, those costs are always given to the consumer. When it costs more for a turkey farmer to raise their turkeys to be able to provide the food that they provide costs more. That means a family has to pay more out of their pocket in order for them to eat. This is absolutely reality. And all of this because of one issue. SIFI designations are based on size, not on actual evaluation of the institution's activities or level of systemic risk posed that might be posed by its complexity and interconnectedness. So my question for you, Mr. Tuggle, regarding the Lukemeyer bill is, you find your bank perhaps going down that similar path. You describe in your testimony a little bit about your bank's operations and your soon-to-be $40 billion bank. Could you tell us a little bit more about what you do? For example, do you have an international presence? Do you engage in complex trading? Tell me about what your services, what you focus on.
We do not have an international business. We are, as you described, we're a bread and butter lender. We take deposits from our customers and we turn around and we deploy those deposits back into our communities, the communities where we live, work, operate, in the form of loans and credit and various services. In terms of risk, you know, we are ultimately really not different than a $10 billion bank or a $5 billion bank in the sense of the products and the services and the approach that we take. It seems to me, to make the point very clearly, that having a $50 billion threshold says that a bank that's $49 billion, $900 million is not systemically important, but a bank that's $50 billion and $1 is systemically important without any difference in what the 49-plus bank does and the $50 billion bank does. It's an irrational way to think about risk to our system, and it is impeding the growth of really fine banks like ours, and it's hurt really fine banking.
So it sounds like you primarily are a bank that offers traditional banking products, retail, commercial lending. Is it correct to say that the products and the services that you carry, that you offer, carry risks that are well understood by your regulators?
It's absolutely the case. It's the same risk they've been regulating, forever.
I run out of time, but again, I just wanted to reiterate that this is not about trying to save banks. This is trying to give people access to the products that they deserve. We talk about when people are harmed, when they don't receive, when a banking institution or lending institution harms, but we don't talk about the opposite side of that. We don't talk about the people that do not receive opportunities because they do not receive the services that were available to them are no longer available to them. Thank you.
Gentlelady's time has expired. With that, we go to the gentlelady from New York. Ms. Tenney is recognized for 5 minutes.
Thank you, Mr. Chairman, and I just want to thank the excellent panel for being here today. This was very helpful and very enlightening. I just want to highlight a few things. Over the last 10 years, the community financial institution industry has undergone dramatic transformation, as you've heard. Since 2006, more than 1,500 banks have failed, been acquired or merged due to economic factors and the overwhelming expensive regulation brought forth by the passage of Dodd-Frank. During that same period, there's been a drought in de novo banks, or new banks. In fact, only 5 new bank charters and 60 new credit unions charters have been granted. Today, for the first time in over 125 years, there are fewer than 6,000 banks and roughly 6,000 credit unions serving the consumers in the United States. This is proof that a community financial institution needs smart, common sense regulatory relief so they can properly serve local communities by assisting with small business startup and consumer credit. I'm working on a bill called the Community Institution Mortgage Relief Act that would offer real relief for small institutions that are barely staying alive in this regulatory environment we currently have. This bill would exempt small community institutions from mandatory escrow requirements and would provide relief from new regulations that has approximately doubled over the cost of servicing, with a direct impact on the consumer cost of mortgage credit. I know that certain institutions wish to provide escrow services to their customers, and they are welcome to do so under this act. This is about autonomy and the choice for smaller institutions. However, for the smaller institutions, like the ones in my district, they rely on relationship banking, something that has seemed to have disappeared in this day and age, and this could help them greatly. I first wanted to address this with Mr. Tuggle, since he so kindly addressed my positively my proposed regulation, or my proposed bill to minimize regulations, actually. And you referenced in your testimony that you supported the bill, but that you would have some suggestions in regulatory changes, how we could make this bill more effective or better. And if you could highlight those, I'd appreciate that.
Thank you. It's fairly simple. I think that what you want to do is if I understand the bill, I believe I do, one of the exemptions is tied back to the $50 billion number, and I just have a problem with that as an arbitrary number that doesn't reflect reality. Let me say, our company, we're $30 billion. We had a large mortgage business we sold in 2008 and basically got out of the business. At $30 billion, we don't provide escrow services today. And it's in part because of the expense of it relative to the fairly lower number of mortgage loans that we make. So I don't know that $50 billion is necessarily.
Let me ask you, what would you use as a determining factor? If not an arbitrary number like $50 billion, what would you say in looking at it in a regulatory framework? How would I change the law to amend it to make it more flexible, so we really address a lot of the community banks who are looking for flexibility, who have suffered under a lot of the regulations, who can't comply, who want to continue their character lending or their relationships with their customers, who they see usually on a daily basis, especially in small areas like rural areas that comprise most of my district.
I would think that I think there's another proposal. Number of loans, the number of loans like this that are made would make a lot of sense, because that proves that this is a small lender that shouldn't be suffering these expenses. And I completely agree, and I think what you said goes across a lot of different areas, and that is, you know, when you put a lot of expense on a small lender or a product or a small loan, you make it less accessible to people. There's less of it, and I would think that what we should be about are laws and regulations that expand the availability of credit. And these small servicers, I think you said it correctly, know their customers, know who they're dealing with, and have the ability to take care of.
Yeah, we did propose on the news, as you indicated in the second half, on the RESPA, the Real Estate Settlement Procurement Act, or whatever that is. I've done thousands of real estate closings, and I just call it the RESPA statement, which is probably filed somewhere and nobody ever sees it again. But I wanted to, so we had a limit on there of changing that to banks that do 30,000 or less loans. Do you think that's something that would be acceptable?
I'm not an expert in these smaller lenders, but it sounds reasonable to me. I would also add that perhaps there would be the opportunity to craft a little broader legislation and to give some opportunity for regulators to address problems and with direction to make credit more accessible.
Thank you. I appreciate that. I think my time has expired. I yield back.
Gentleman's time has expired. That we recognize the gentleman from Arkansas, Mr. Hill, who is, in addition to our committee today. He's one of our important members of the full committee, but he's also the sponsor of one of the bills that we're considering today, and I look forward to his discussion. Ms. Till, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Appreciate you and the ranking member holding this hearing. Thanks for letting an interloper from the committee come and be a part of your hearing today. And thanks for your work on the SIFI designation. I think so many people have simply tried to move the number from $50 billion to a higher number, particularly over in the Senate. And I think if I were a regulatory policymaker, I would want a much more substantive activities-based approach. So thank you for your leadership on that. We're back talking about TRID today. We've talked about that a number of times in this committee since the rule was finalized back in 2013. The origin was, of course, under Dodd-Frank to ask the CFPB to consider merging the truth in lending disclosures with the real estate settlement disclosures. The intent was a streamlined, simpler, better form for consumers. That's sort of like the guy who wants a thoroughbred and goes into breeding and produces a camel. We really didn't get that. And in 2015, when the rule went final, it had so many problems with it that the House overwhelmingly passed my bill, the Home Buyers Assistance Act, 303 to 121, which was to try to delay problems with liability associated with trying to implement this rule. Again, the CFPB recognized that they had trouble with their rule, and they reproposed it and asked for more comments, and those comments poured in. And then in April, Director Cordray testified before us, and I discussed with him the problems I had with the lack of clear, legally binding guidance coming out of the CFPB generally and on TILA-RESPA in particular. So today, we tackle one of those small challenges, and I appreciate Mr. Tuggle and Mr. Quadman's comments on this bill. This bill does two things. Number one, it tries to make sure that we provide accurate information in a very confusing part of the rule, which is disclosing what is the title cost to the consumer. And you can see on your screen, the rule attempts to make a marginal cost analysis. It's on the left. That's what the CFPB currently describes or prescribes for title companies to disclose on that closing statement. But it doesn't really, in my view, do a very good job of it. So part one of this bill simply says we think that the accurate, actually charged amount for the owner's title policy, that the seller typically pays to cover their reps and warranties on that they have good title to the property they're selling, and then the lender's policy that is typically paid for by the borrower that's covering liability on closing the loan. Mr. Quadman, pretty confusing. What are your thoughts on this part of the bill's change?
I think it's very welcome. I'm laughing a little bit because in a prior life, I didn't do as many real estate closings as Ms. Tenney did, but as a recovering lawyer, I did my fair share. And I think you point out the problem that the rule itself doesn't convey appropriate information to consumers, nor, I mean, with the passage of the Dodd-Frank Act, we were supposed to help consolidate and streamline closing documents, and clearly we still have a lot more work to do, and I think this bill is an important first step to trying to do that.
I appreciate that. The other portion of the bill that was referenced by my friend from Minnesota is trying to align the errors in the bill from 60 days to 210 days. The logic here was to align it with what Dodd-Frank's rulemaking prescribed on the qualified mortgage rule of 210 days. It's not a number pulled out of thin air. It's pulled out of one of the most important rules that came out of Dodd-Frank, which is trying to define a qualified mortgage and then defining that for the secondary market. So we attempt to align that error discovery process for TILA-RESPA to that 210-day note that was a result of qualified mortgages, also a part of Dodd-Frank. As I say, this is a 1,800-page rule trying to merge these forms. I've heard lots of comments from my bankers. Some of them have tongue-in-cheek said that TRID stands for the reason I drink, which is as I say, tongue-in-cheek, but it's seen a lot of product problems for consumers. One-time closed loans are now very difficult to do, if not impossible, under the combined form. And so I think consumers have been hurt. Closing times have been extended. So I'm pleased that this is a good step forward, and I thank the chairman for letting us have that discussion today.
The gentleman's time has expired. With that, we go to the gentlelady from Arizona, Ms. Sema. We also, who's not a member of the committee, but is a distinguished member of the full committee, and we welcome her, and she's recognized for 5 minutes.
Thank you so much, Chairman. And thank you, Chairman Lukemeyer, for working with me and several other of our colleagues to introduce the Systemic Risk Designation Improvement Act of 2017. As you all know, this common sense bipartisan legislation removes the arbitrary $50 billion asset threshold established by the Dodd-Frank Act and requires the Federal Reserve to establish a process to formally designate individuals or groups of financial institutions as SIFIs based on a variety of factors, including size, complexity, substitutability, and interconnectedness. My first question is for either Mr. Tuggle or Mr. Quadman. While not all enhanced prudential standards may be needed for banks below the globally systemic important bank level, if the Federal Reserve felt it was appropriate to apply some of those standards based upon the circumstances of a particular institution, would they be able to do so under the legislation that we've proposed?
Yes, they would be able to. So I think one of the things that the bill does is that when it looks at activities too, is it looks at the existing criteria that the Fed has. So the Fed still could, take actions, and they still could have, some enhanced regulation. So I don't think it precludes them from doing anything. And in fact, what it does is allows the Fed to tailor a regulatory scheme to fit that bank. So we can make sure that that bank is acting in a way that they should, and that regulation fits its profile.
Thank you so much. My second question is for Mr. Tuggle. I think we should all be able to get behind the idea of smarter and better tailored regulations. So, Mr. Tuggle, can you tell me what you think about a smarter or better tailored regulations impact is on the larger financial system? Does it make it safer, and if so, how?
It certainly does make it safer because it's focused on what the real issues are. Regulation that identifies a risk, a real specific risk, and responds to that is better than regulation that's just across the board, unrelated to what the risks are. This is a Dodd-Frank example that's very real for us, the Volcker Rule. We're subject to the Volcker Rule. We're a plain old bank, and there's no real Volcker sorts of concerns about us affecting the financial stability of the United States. But the year that we had to start to implement Volcker, to understand it, and to develop processes and all, we spent over 6,000 hours of time of smart, talented people, and we put in place what we had to put in place, and I don't think it added one smidgen of greater security to our financial system.
Yeah, thank you. My final question is for Mr. Quadman. Mr. Quadman, in your opinion, would the elimination of this arbitrary $50 billion threshold and instead creating more appropriately tailored regulation of banks of all sizes, would this result in increased lending to small and medium-sized businesses in Arizona and other states across the country?
Yeah, and I think for two reasons. One was the issue I raised earlier in terms of how regulatory compliance is really shutting out banks from providing smaller loans to smaller businesses. Mm-hmm. The other thing is what we consistently hear from our business members is that increasingly, particularly when you're talking about a bank that's under a SIFI designation, that businesses generally had some form of a relationship type lending or a relationship with their bank, so that the loan officer would understand a business and the cycle of that business and would understand their financing needs, et cetera, and can help work with them to achieve their needs. The problem now is that the regulatory compliance people are more often having to say as to whether a loan should be granted or not. So I think you would see increased lending to businesses for both of those reasons. One is the smaller loans, we would be able to open up that flow. The second is that we would empower the people that understand the business to to actually weigh the merits as to whether a loan should be issued or not. And I think that would free up a lot of lending that has currently been bottled up, as well as the fact that with the regulatory costs going down, those banks are just going to have more money to issue loans.
Thank you so much, and thank you to all of our panelists. Mr. Chairman, I just want to thank you again for introducing this legislation. It's been a real privilege and honor to work with you on it. I commend you on the work, and I look forward to getting this bill to the President. Thank you. I yield back.
The gentlelady yields back. We thank her for her comments. We have exhausted all the questions for today, and we want to thank the committee or the panel for their fine work. The purpose of this hearing was to look at a group of bills that we believe fix problems or tweak the existing law to make the financial services entities that they regulate to be better able to serve their customers and clients. And with regards to the SIFI bill that is my bill, and we've discussed here at length, we had a visual aid over here on the side whenever we were discussing it at a previous time. It had 20,000 pages of paper, which is kind of an average, probably it's a low on average of what a lot of the mid-sized regional banks are facing whenever they do a stress test, living will compliance for their designation. Cost millions and millions of dollars, and it was a whole table over there, like 5 by 3 by 3 of paper, which a lot of times doesn't get read. But I think it goes back to, in my mind, the banks are in the business of assessing risk. That's what they do for a living. They assess risk and they decide which risk to take by working with the customers and the businesses and their clients. And regulators should be in this business of assessing the bank's ability to assess risk, not managing the banks on the risks to take, which is what's going on. And so I firmly believe that we're on the right road with this. A threshold is an artificial get-out-of-jail-free card for some folks, which gets the regulators off the hook from doing their job, in my mind. And I think, with regards to a couple other issues we had in committee, I just want to comment on briefly. We had a banker talk to me recently, and he made a comment with regards to Blaney said, I can do a $50,000 vehicle loan. It takes about 60 to 90 minutes. Paperwork is about that thick, but it's a depreciable asset and it can move. I can do a $50,000 home loan. The paperwork is this tall. And in fact, we had a gentleman here that was testifying one day, and I asked him how many pages he was. He said, Congress, we don't measure it by the page anymore, we measure it by the pound. Anyway, it would be this tall, and it takes 60 to 90 days and probably costs an average of $2,500 to do. The same amount of money, and here you have an asset that is not mobile, it appreciates in value, and yet over here you have an asset that is mobile and depreciates in value, and look at the difference in paperwork, look at the difference in risk, and yet it's out of whack. And I think this is what we have to keep in mind. The common sense, how do we approach these things? How do we help our constituents and consumers be able to have access to credit when they're under this big burden over here with regards to home loans and the confinement of the regulator, or the banks, and be able to provide that service. So we, again, want to thank each of you for your testimony today and your expertise that you brought to our discussion. Without objection, all members will have 5 legislative days within which to submit additional written questions for the witnesses to the chair, which will be forwarded to the witness for their response. I ask our witness to please respond as promptly as you're able. Without objection, all members have 5 legislative days within which to submit extraneous materials to the chair for inclusion in the record. And with that, the hearing is adjourned.